said you had no further questions. I was the one who wanted to ask further questions, Mr. Freund.
Well, Chair, what I was about to do, if I can refer you to bundle 2 of page 41, I was about to take
What page?
comments there, and I made it very briefly. And you then, Chair, said, well, perhaps it needs a little more time.
Yes, okay. What page did you refer to just now?
741 in bundle 2.
Oh, okay. Yes, okay, thank you. So I think yes. Go ahead.
My suggestion, Chair, is Chair myself through this, and that as we go along, if you wish to pose whatever questions, then of course you should do so.
Yes, no, that's fine. Let's proceed on that basis.
Thank you, Chair. Mr. Selfe, on the previous occasion when you testified, you had really completed what we might call a chronological narration of your experience on the portfolio of allegations of corruption and the like relating to Bosasa and its related companies. From that, you then move on in your affidavit to deal more broadly with your observations and interpretations of the role played by portfolio committees. And you say in paragraph 2 that paragraph 7.2 that you would argue that many of your colleagues on the committee at the time did not obey, respect and uphold the Constitution and did not perform their functions as MPs to the best of their abilities. Is that correct?
That is correct, yes.
And then you expand on that in paragraph 7.3, and then you say there are many reasons for this failure in view. You start to list those reasons. And the first of those that you referred to in paragraph 7.3.1 was the lack of independence of MPs generally, and particularly in the ANC. Would you care to comment on that issue?
Yes. Well, the South African electoral system is structured in a particular way at the moment, whereby political parties provide closed lists of candidates for the National Assembly to the electorate. The electorate does not vote for any particular candidate, and votes for a political party. And the political party gets the requisite number of seats depending on their proportion of the vote. But the lists themselves, while notionally constructed by the branches and regions and provinces, are in fact finalized by the headquarters of the party. Very few voters know who's on those lists. And in the end, the person or the group of people that who put that person, that candidate on the list, can remove that candidate. That's very highly centralized, and it does not lend itself to the independence of the MPs.
Well, I'm sorry, Mr. Frank. I'm sorry. Mr. Selfe, I would like your comment on the proposition that as long as members of Parliament in our current electoral system do not have adequate protection to be able to act in the best interest of South Africa are able to instruct them how to vote or how to perform their oversight functions, and the instruction is not one that makes sure they do their job properly. And as long as parties can take steps to prejudice somebody who may have decided to act in what they believe is the best interest of the people in that situation, then it's going to be very difficult to have, particularly the members of the majority party, and we have the ANC majority party now, but it could be members of whatever majority party they may be in the future, to put the interests of the people of South Africa first, where they are in conflict with those of the party. So the proposition being, unless the system provides adequate protection, then maybe we may as well forget that we would have effective oversight and proper accountability on the part of members of the executive and parliament. What do you say to that proposition?
The proposition is completely correct, Alexander, because at the current moment, as you can ask a number of people who have been expelled from Parliament for not agreeing with the party line, or simply didn't get re-elected at the next election, there is a very chill wind that blows as a result of the way that the current electoral system is structured. So yes, you do require protection for members of Parliament who are bona fide doing what they regard as being the work of the electorate and in the interests of South Africa. But I would argue that it goes further than that a member of Parliament needs an independent mandate, not just a mandate from his or her party, and that mandate should ideally come from the constituency system. But I introduced a private member's bill in 2013 to provide for exactly that constituency system, so that members of Parliament have an independent power base, an independent mandate. But that bill was rejected by every other political party in Parliament. It never saw the light of that.
Okay, now thank you for that comment, Mr. Selfe. But maybe you could speak up a little bit. I can hear you, but I would hear you better if you spoke up a little bit. Now, what you have just told me about the private members' bill, I think that's what you said that you introduced, but it didn't receive enough support. Seems to reflect my understanding, but you might be able to enlighten me better, because you are in Parliament and have been there for many years. You are a senior member of Parliament. You have experience about how things happen there. My sense is that the bosses of most of the political parties, as I'm saying the bosses for just to indicate the leadership, most political parties don't seem to have an appetite for a system where the party can't instruct its members in Parliament how to vote. I may be wrong, but I have this impression that it looks like that might be one area where all these different parties seem to have no divergence of opinion. I may be completely wrong. What is your impression on this point?
Well, as somebody who was in fact a party boss of my own party. I can tell you that it is very convenient if you are a party boss to have the sort of electoral system that we have at the moment, because you can ensure discipline, you don't have to worry about quorums, you don't have to worry about people getting out of line. But I would argue that that does not necessarily serve the interests of democracy, and it doesn't serve the interests of accountability or oversight. You ought to be in a position where a member of parliament is able, on bona fide grounds, following his or her conscience and good reason, to take a view that is different from that of the party leadership.
Now, you may be able to say this. You might not be able to say. Do you know whether, for example, your party, the DA, whether it shares this view that you have just expressed, or whether its position is different?
No, Judge Nkandla, my party is committed to introduce a system of constituencies where members of parliament are elected directly by the voters of South Africa and accountable to them. That was the basis of the private members' bill that I introduced in 2013. But it saw no favour, or had no favour with any other party in parliament.
What do you understand to be the main grounds of objection to the proposal of using the constituency system? I ask this question because it seems to me that if the country used the constituency system to a very large extent, we would be able to improve parliamentary oversight by members of parliament, including those who may belong to the majority party, because under that system, I have to be elected by the majority of voters in my constituency. And those voters might not just be those who belong to my party, it might be other people who think I'm doing a good job in the constituency. And if I believe when, for example, there is a motion of no confidence in a president or in the president at a certain time in parliament, and I truly believe that being faithful to the Republic of South Africa in accordance with the oath of office that I took as a member of parliament, I should support that motion because the president has failed his duties, or is no longer good to lead the country. And I know that my constituency will have no problem with that, and maybe they actually want me to vote that way. Then, if my party wants to punish me, or dismiss me because I didn't follow an instruction to vote against, maybe I may be dismissed and might be out of a job for a certain period of time, but the next elections, my constituency might vote me back, and I go back to parliament, or maybe even if my party can dismiss me, that would not result in my removal as a member of parliament. Therefore, I would know that going against my party on this issue, on this motion of no confidence, is not going to result in me having no job and not being able to put bread on the table for my family, because I know my constituency appreciates my...
Had the ability to prevent you from being promoted, but not to make you lose your job. That is the basis of the independence of members of parliament that allows them to do their job. There is only one proviso, of course, and that is that the Constitution enjoins us that the composition of the National Assembly shall in general be proportional to the votes cast. But there are various mechanisms where one can make sure that that happens. But in broad principle, you are correct.
And what is your understanding of what the main grounds of opposition are from other political parties to the idea of the country using the constituency system?
Well, I don't know about all the other political parties, but at the time of the negotiation of the Constitution, it was felt that particularly minorities would not be adequately represented if there was a constituency system. And in addition to that, it was felt that particularly women find it difficult to represent a constituency when there's no degree of proportionality. So I think it really has to do with making sure that the National Assembly is representative of everyone in the right sort of proportions. Rather than a constituency system which may result in further domination by a particular party.
But I guess that there may be ways to address that. I don't know, I seem to have heard or read somewhere that there could be a situation where it's a mix of the two systems, constituency and the current one. Do you know anything about that idea?
Yes, sir. That in fact was the basis of the bill that I introduced, where 300 members of the force and 100 of those members would be elected from a proportional list, so as to ensure that the representation of the National Assembly was as close to the proportions who voted for particular parties as possible. So indeed, it is eminently possible to work around that problem.
Yeah, I think it's just going to be important for all of us as South Africans to consider a way of giving some protection to members of parliament who might want to do the right thing for the country, where their party might not think that's the right thing. And what one has in mind here is a situation where quite clearly it's not the right thing, but the party says this is what we want our members to do. Because I think in the current system of oversight, I mean, the evidence that I've had in this commission, it's as if there is no oversight in Parliament. Of course, there are certain committees that seem to have really tried. But by and large, it seems that the performance of oversight functions comes mainly from the opposition parties and not from members of the majority party. Whereas if everybody took that function seriously and wanted to do it effectively, then there could be a lot of difference that could be made in how things are happening in terms of corruption and just proper governance. So if we leave the situation as is, I don't see any chance that if we were to be faced as a country with allegations of state capture in the future and a huge rise in corruption, I don't see that Parliament would be able to play any better role than they played over the past X number of years. Are you able to give me any comment?
I agree with that proposition, Judge.
No, thank you. Mr. Freund, you may continue.
Thank you, Chair. Just for the sake of clarity, Mr. Selfe, there is, as I understand it, but I'm asking you to confirm if you happen to be able to do so. There's a provision in the Constitution which makes clear that if a member of Parliament is expelled from the party on whose list that member came to Parliament, that member then ceases to be a member of Parliament, and so loss of your party membership automatically results in loss of your seat as a member of Parliament. Am I correct in that regard?
Absolutely correct.
And so that provision also has implications, it seems to me, I'm putting it to you for your comment, on the degree to which members of Parliament are likely to follow their conscience in defiance of party instructions. Would you agree?
I would agree, because in the end, it is the political party that orders the list, and if one can be expelled for holding a different point of view, then it does cause a chill wind to blow on anybody who might be inclined to do proper oversight.
And in your affidavit, you just refer in passing to the position of Mr. Andrew Feinstein. I appreciate that it traverses a little beyond the scope of the current commission, but if you could just maybe in one paragraph summarize the Andrew Feinstein experience.
Yes, well, as I remember, Andrew Feinstein was one of the early whistleblowers on the arms deal. He tried to, as a member of the majority party, tried to have Parliament take these allegations seriously. He failed in that quest, and he was gradually worked out of the ANC.
And he was not only a member of the majority party, he was a serving member of SCOPA, before which committee the arms deal acquisition question was being investigated. Is that correct?
That is correct, yes.
Therefore, due to his insistence or persistence in trying to ferret out the details of the alleged irregularities in respect to the arms deal, effectively you say he was worked out of Parliament.
That is my understanding, yes.
Now, in paragraph 7.3.1.4, the footer page 743, you deal with what you call the hierarchical nature of the African National Congress. And you say that this tends to mean that senior office bearers, such as cabinet ministers, are treated with deference, if not obsequiousness. Could you just tell us the basis on which you make that assertion?
I make that assertion on the basis of my experience when members of the executive appear before various committees, and invariably they're treated with kid gloves. I don't think the hard questions are necessarily put to them, and there are, as I understand it from some of my colleagues, consequences for people who give members of the executive or senior members of the organization a torrid time when they come to committee.
Now, can I take you to the end of your paragraph 7.3.1.5? In that subparagraph, you're dealing with the issue of ANC study group meetings. In fact, you say that on one occasion, really by error, you found yourself attending an ANC study group meeting. Is that correct?
That is correct. I chanced on a meeting I thought I was part of, but found out that I wasn't part of it. It was an ANC study group.
And you then go on to deal with a particular instance which you say illustrates the impact of decisions taken in the study group in relation to the degree of oversight then carried out in the portfolio committee meeting that follows. And you refer at 7.3.1.5 to an instance where you tried to raise the topic of the award of a fencing contract to SA Fence and Gate. Could you please just elaborate on that to illustrate your point?
Yes, indeed. I had received information from a source, and I tried to raise the topic at the Portfolio Committee on Correctional Services, because obviously the subject of the award of fencing contracts was very controversial because of the controversy that had surrounded the award to Pezulu previously.
Pezulu being a Bosasa-related company.
The source that I talked to said that there were irregularities in the award of the contract to SA Fence and Gate. I tried to raise the topic at the committee. The committee members from the majority party simply wouldn't entertain a discussion about this at all.
And why, if you do you link that to the study group issue?
Well, in my experience, and I'm also relying on information that has been given to me by various other people, a committee meeting is preceded by a study group. Very frequently, that study group is attended by the minister and or by members of the civil service. And a line is taken about certain topics, a predetermined line, and if the majority decide on that, or if the instructions come from the majority party that that is the party line, then in my experience, I found it very, very difficult to elicit any sort of sensible conversation on the committee on topics that have been pre-discussed by the majority party.
Thank you. I want to move on to your paragraph 7.3.2. It's a slightly more prosaic matter, but you deal with what you call the unsatisfactory modus operandi of portfolio committees, and you commence by dealing with the problems that flow from the manner in which the agendas for these committees are determined. And I imagine that's tied in with the bigger problem of the sort of annual cycle of oversight, or the annual cycle of functions of the committee. So I'd like you to talk to that briefly, and in particular, the implications of that cycle and the nature of that work for the capacity of portfolio committees, when appropriate, when matters come into the public domain, to actually exercise speedy and effective oversight on important matters that then arise and are not necessarily catered for in this cycle of meetings.
Yes, you're absolutely correct. At the beginning of a quarter, the committee normally determines its agenda for the quarter. There are a number of steps that a committee has to take. It has to interact with the department and with entities very frequently. There are limited opportunities for meeting as a portfolio committee and limited time to do that. And so when a topical subject arises, say a controversy around the award of a contract or the unsatisfactory behavior of a particular individual, it's very, very difficult to get a committee arranged to deal with that matter, bearing in mind the predetermined nature of the quarterly programs. I have achieved that sometimes in the past, but a lot depends on the chairperson, and the chairperson is bound by, I imagine, the mandate given to him or her by the study groups.
That leads directly into my next question. If I can refer you to paragraph 7.3.2.3, in the first sentence, you make the following point. You say, a lot depends on the latitude the chairperson gives to members and the manner in which questions are asked. Now, before we come to the manner in which questions are asked, you're drawing attention to the importance of the identity, character, and disposition of the chairperson of the committee. Would you like to elaborate on that a little further?
Yes, indeed. Obviously, in my time in Parliament, I've served on a number of committees with a number of chairpersons, and the chairpersons that encourage debate and encourage oversight, and there are chairpersons who are reluctant to do that. So I think that if you really want to have proper oversight, you need to look at something like the Scopa model, where the chairperson of the committee is given to an opposition party, and that chairperson has then an interest in an interest in making sure that all the facts come out and are presented to the committee, rather than an interest in making sure that the matter is effectively put to bed.
Now, you deal in this particular paragraph that I was quoting from with the modus operandi in relation to questions, how MPs ask their questions and how they are responded to. Would you just clarify, as a matter of fact, how that happens, and then comment on its functionality?
Yes, well, what ordinarily happens is that a chairperson will then invite questions from MPs after the presentation or the testimony of whoever's appearing before the committee is finished. And the MPs ask those questions in turn. Some MPs ask 3 or 4 questions. The whole question time takes probably half an hour or 3/4 of an hour. And the department or the entity or the witness then responds. But because they have maybe 25 or 30 questions to answer, they don't answer them necessarily with the degree of specificity that is required. Sometimes the questions are fudged, sometimes inaccurate information is given, and it's not always possible to follow up or to clarify on those replies.
Moving on to your paragraph 7.3.3, I think essentially you make the point that there is a heavy burden on portfolio committees, and that might account, by implication, in part, for example, the way in which the Bosasa issue seems to have simply just fallen off the agenda.
Yes, the committees do have a heavy agenda, but in my experience, what skillful chairpersons are able to do is to distinguish between what is really important when it comes to oversight and what is less important. And they then prioritize the more important aspects that need to be interrogated, and they tend to let the other matters slide.
You raise in your affidavit, paragraph 7.3.3.2, the Nkandla saga. Now, the matter has already been before the Constitutional Court, which has expressed itself firmly in the adequacy of parliamentary oversight. But just for the record, and extremely briefly, what are your comments about the manner in which Parliament dealt with that issue and how that ties in with the points that you've been trying to make about portfolio committee oversight?
Yes, well, I was a member of all three ad hoc committees on Nkandla, and in fact went on an oversight tour of the Nkandla homestead. But I can tell you that all the efforts that we made to have key people called to the committee, to have documents produced, to have the then president himself come before the committee, were blocked by the majority party. In the second ad hoc committee, I constructed an alternative report, which was put to the vote and simply voted down. So it was not a pleasant experience. It was very frustrating because one wasn't able to get through the inbuilt majority in that ad hoc committee.
A former witness has referred to the fact that the rules governing Parliament, the National Assembly, actually provide that minority reports are to be permitted and to be appended or to be submitted together with majority reports. Are you saying that your attempt to invoke that simply failed?
No, it was appended as a minority report, but it was most certainly not accepted. And in that respect, of course, the fact that we find it difficult to budge the majority has led to a great deal of litigation in various courts to enforce what we regard as being our democratic rights.
Right. And then you make a point near the end of your affidavit, which is based on earlier parts of your affidavit and also based on the detailed material that we haven't traversed in the PMG's report on Bosasa, about the implications of political and administrative role player turnover. If you could just talk to that issue very briefly. And it seems to me that this is not confined to your committee. This seems to be something we see in a host of committees that have been the subject of this commission's investigations.
Yes, indeed. There has been a very high turnover in my period on that committee of both political office bearers and administrative heads of department. Sorry. And while one can sometimes get away with having a new minister every couple of months, it's very much more difficult if one has a change of national commissioner, because the national commissioner is the accounting officer. The national commissioner must order and manage the department. And if he or she only has a couple of months in office, it becomes very difficult to provide administrative continuity and stability.
Mr. Selfe, subject to one qualification, that is all that I wanted to ask you. The qualification is this: you are aware of what is contained in your affidavit. Is there anything in particular that you feel needs stressing that I haven't given you the opportunity to raise?
I don't believe so.
Thank you. Then I have no further questions.
Thank you very much, Mr. Selfe, for availing yourself to help the Commission. We appreciate it very much. You are now excused.
Mr. Chair.
Mr. Freund, your next witness.
Yes, I just want to check that the next witness is in fact connected. Let me just check that. Yes, the next witness will be Mr. Matt Johnston, who I believe is connected to this video conference facility. Perhaps he should come on screen and unmute.
Yes, I'm here. Good morning.
Good morning. Mr. Freund, is his affidavit in this bundle or a different bundle? Is it in that one? Okay.
It's Exhibit ZZ3, Bundle 1, page 217 and following. Quite an extensive affidavit and annexure. First page of the actual affidavit being page 217 in Bundle 1.
Okay, I've got it, Mr. Freund. Thank you.
Thank you. Mr. Johnston, do you have a hard copy of your own affidavit and annexures paginated in accordance with the pagination system adopted by the Commission?
Yes, I do.
And if you look at page 217, is that the beginning of your affidavit?
Yes.
And if you go to page 325, is that your signature?
Yes, it is.
And have you had an opportunity to read?
I'm sorry, Mr. Freund, that we need to have the oath administered slip your mind, and I was, let's do that first. Registrar, will you administer the oath of affirmation?
I would prefer the affirmation.
Yes, she will then administer the affirmation.
Please state your full names for the record.
It's Matt Paul Johnston.
Do you have any objection to taking the prescribed affirmation?
No, I don't.
Do you affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth? If so, please raise your right hand and say, I truly affirm.
I truly affirm.
Thank you, Mr. Johnston. Mr. Freund, you may then start afresh.
Thank you, Chair, and I apologize for the oversight. Mr. Johnston, we have just referred to page 217. Will you just confirm again for the record that that's the beginning of your affidavit?
Yes, I can confirm.
And that's the signature page 325 of your signature.
Yes, that's correct.
Mr. Freund, I don't know what's happening. The last two questions you have made, they were not very audible. I don't know what's wrong with whether it's the technology or you were speaking softly. Do you want to try again, starting from the first question?
I will try again, Chair. I'm concerned that there may be a bandwidth problem.
Yes, I can hear you well now.
Mr. Johnston, I think now for the third, I just want to confirm that the affidavit from page 217 to page 325 is your affidavit, and at 325 we find your signature. Is that correct?
Yes, that's correct.
And have you had an opportunity to reread your affidavit, and are you comfortable that it is correct?
Yes, I have, and yes, I am.
Now, you say in paragraph 1 that you're authorized to propose to this affidavit.
Sorry, Mr. Freund. Do you request that I admit the affidavit with its annexures as an exhibit?
I most certainly do, Chair. As exhibit Z3.
It will be exhibit what?
ZZ3.
The affidavit of Mr. Matt Paul Johnston, which starts at page 217, will, together with its annexures, be admitted and will be marked as exhibit ZZ3. Okay, you may proceed.
Thank you, Chair. Mr. Johnson, you say in paragraph 1 of your affidavit that you are the Parliamentary Engagement Manager at the Organisation Undoing Tax Abuse, known by the acronym OTA. Is that correct?
Yes, that's correct.
And that you have been duly authorised by OTA to depose to this affidavit on behalf of that organisation.
Yes.
And you make clear in paragraph 2.2 that as from September 2017, OTA, and presumably primarily you personally, were engaged or attended the meetings of the portfolio committees which you deal with in this affidavit. Is that correct?
That's correct.
But you make clear that you also deal in this affidavit with proceedings prior to that date, which you did not personally attend, but where your information is derived from the records primarily of the Parliamentary Monitoring Group. Is that correct?
Yes, that's correct.
And you deal in paragraph 2.1 with your assessment of the accuracy or otherwise of the Parliamentary Monitoring Group's records of portfolio committee meetings. Could you just comment on that briefly?
Yes, and as I indicate there, it is the best record that I'm aware of. We have looked at internal parliamentary meeting minutes, but we found that those are quite inadequate. They are frequently incomplete and sometimes inaccurate, or just conveniently omit information that some people would rather not publish. So we use PMG as what we see as the best record.
And when you have regard to meetings that you've personally attended, and you then have regard to the manner in which they are recorded by the PMG, what is your comment on the accuracy and completeness and otherwise of the PMG?
I'd say they're almost 100% accurate. Frequently there is something that is omitted, and I do indicate that because it is individual people attending those meetings with a digital recorder, and they would then subsequently transcribe those recordings. But there is never content that was not in truth in that meeting. But sometimes there are small omissions, but by and large, I'd say they're accurate and complete.
Now, I'd like to take you to paragraph 3.3 of your affidavit to give an indication of what your objective was in compiling this affidavit. Perhaps you could just take me through that paragraph.
So the purpose was just to provide a chronological series of meetings that we are aware of that dealt with the topic of state capture. We used particular keywords to search for those meetings, for example, the Gupta family, just using them as an example. But in particular and in the main, we focused on a handful of portfolio committees that ostensibly held inquiries or actually held inquiries. And we deal with those minutes and how they dealt with the topic or the concept of state capture.
You say in the paragraph, the aim is to describe systemic shortcomings in parliamentary oversight practices that we have identified over the course of several years of professional monitoring and evaluation in Parliament. Is that correct?
Yes, that's correct.
And in fact, perhaps it would be helpful if you just describe what is the very purpose of the unit within OTA in which you are engaged, the parliamentary, and what are the duties, functions of a parliamentary engagement manager at OTA?
So what we've been doing as an organization, and from 2016 and earlier on, we've been laying several criminal charges and pursuing issues of tax abuse, which is basically similar to the abuse of authority in government. And many of these issues that we dealt with would end up at law enforcement agencies. And I think what my superiors in the organization realized is that those issues do not reach any sort of consequence. And we decided to really start some operation in Parliament to not only come to grips with what they are doing in terms of oversight of the executive and how they spend taxpayers' money, but to really put some of the issues that we've been dealing with that were fruitless at the law enforcement agencies to put to parliamentary committees and to try and get some justice there. So in the beginning, we monitored what particular committees were doing that were relevant to our mandate, to our projects, for example, in the transport, energy, water sectors, also in justice and constitutional development. We monitored those committees to understand how they're actually exercising oversight, whether they are, because frankly, the position was that surely they are not carrying out oversight because we are seeing the effects of impunity. So the purpose was initially to come to grips with how they were doing things, but then really to try and improve the way they carry out oversight.
And in paragraph 3.5, you summarize your conclusion, and what then follows over hundreds of pages is detail. But you say, to our profound disappointment, we have repeatedly experienced in several portfolio committees of the National Assembly and Parliament the brazen flouting of genuine and non-partisan oversight of executive conduct. Is that a fair summary of your conclusion?
Yes, it is.
Now, just bear with me, please. I'd like to take you to paragraph 5.1 of your affidavit. And again, I only want to deal with this extremely crisply and briefly, because the issue of the Waterkloof landing incident has been the subject of evidence before the Commission already. And that's for our 5.1.4, that inappropriate utilization of state assets by a private family, the Gupta family, well connected to high-ranking politicians, was answered by a member of cabinet as something that parliamentarians need not concern themselves with. You say members of the ruling party did not object to this explanation. Firstly, who was the cabinet minister to whom you're referring?
It was the then Minister of Justice and Constitutional Development, Mr. Jeff Radebe.
And could you just elaborate on why you say members of the ruling party did not object to this explanation?
Well, the Hansard record is there. There were some objections from members of the opposition party, and I would have wished to be a little bit more privy to how debates on matters of public interest go, but I have never been fortunate enough to attend such. This instance in 2013 was the first debate in the National Assembly on an issue of public importance, as far as I'm aware, since the year 2000. So those are very uncommon, but there were exceptions.
Sorry to interrupt you, but you're referring to a particular technical device which is provided for. If you could just explain that.
Yes. The parliamentary debate on a matter of public importance is something that can be requested by any member of parliament, requested from the speaker. And in this instance, she acquiesced and accepted that request. And that's why this debate actually happened. And this is something that doesn't happen very often, is my point. It happens very seldom. And that is just a testament, one of the many testaments, in my view, of the fact that there aren't many relevant debates in Parliament on issues that are of importance today. That's the point I was trying to make.
When you talk about debates in Parliament, are you referring to debates on the floor of the National Assembly?
Amongst others, yes.
And did you have regard to Hansard, or what was the source for your comment that members of the ruling party did not object to this explanation?
Yes, precisely.
I'm sorry, Mr. Freund. I'm sorry, Mr. Freund. I want to make sure that I'm following. The explanation you talk about, is it the one that is dealt with at paragraph 5.1.3? That is said to have been provided by Minister Radebe? Mr. Freund?
Yes, I hear you, Chair. I assumed that the question was directed to Mr. Johnston.
Oh, no, to you.
Maybe shall I cover the material again?
No, I just want to make sure that I understand. That the explanation you are referring to.
Yes, let me.
Okay, you go.
Chair, after paragraph 5.1.3, there is in the first sentence of paragraph 5.1.4, the allegation by Mr. Johnston that says that, and he's explained now, that Minister Radebe said that the alleged inappropriate utilization of state assets by a private family, the Gupta family, was something that parliamentarians need not concern themselves with. That's what Mr. Johnston said.
Oh, yeah, I see that. Yes.
And what you say, Mr. Johnston, is that once Mr. Radebe had expressed that view, you say members of the ruling party did not object to that explanation, as I understand your evidence. Is that correct?
Yes, and I should just qualify that by saying he also referred to it being dealt with by the Public Protector's Office. And this is a point that I make further on, is that very often issues of parliamentary oversight are silenced on the basis that they are being dealt with either in the judiciary by some court or in a Chapter 9 institution.
But the statement, if you have got the statement right, that Minister Radebe said the utilization of Waterkloof, effectively, that the Guptas landed their plane on Waterkloof was effectively none of the business of members of parliament. That's extraordinary. Are you quite clear that you have reflected correctly what he said? I'm not saying, I'm not meaning you recall word for word, but that's the point he made. Are you quite clear that that correctly reflects what he said?
Yes, Chairperson. So this is reflected in the Hansard.
Yes.
And more specifically, if I just may elaborate on that, it is, it's difficult to reflect the precise tone of a minister speaking in the National Assembly, but it was a tone of dismissal, and that the issue was being dealt with elsewhere, and therefore the members of parliament did not need to concern themselves with that issue.
But what is this story that a matter is being dealt with by the public protector, therefore parliament shouldn't or can't carry out its oversight function? I seem to have some difficulty with that. So in order to make sure parliament won't be seized with a matter, you must just refer it to the public protector or take it to court. Then parliament will never exercise its parliamentary oversight responsibilities in regard to that matter.
Yes, Chair. That's the tone that came across in my view.
If it's taken to the public protector, the public protector investigates. Sometimes it might be for a year or 2 years or whatever the period. She issues her report. If her report is taken on review in the High Court, it could be 5 years before we see an end to the litigation. By that time, how does it help to go back for it to go back to Parliament? So it seems to me that if you say if a matter is before the public protector or if a matter is before the courts, Parliament can't debate it, can't debate it and can't demand answers or explanations from the executive. It means that in that way you are depriving Parliament of the opportunity to perform one of its very important functions over the executive. What's your comment on that, or am I missing something? Mr. Johnston, do you have any comment to...
I completely agree with you, Chairperson. And
yes. But you say that after...
Yes, I can go further and say...
Yes, go ahead.
Sorry, I think there's a lag. Yes, I think that's exactly the point. And later on in the affidavit, I emphasized this, that it is actually precisely 4 or 5 years later that the issue of this family and how they relate to important decision makers in government was actually picked up substantively only by some. So that's the period of time that passed. And in that time, it is our view that that was the zenith of state capture. But consistently when this issue was brought up, it would always be downplayed, it would be purposefully ignored, or some external authority would be referenced to justify dropping the issue.
Yes, Mr. Freund, continue.
Thank you, Chair. Now, on the question of delay, in your paragraph 5.3, which has many subparagraphs, you deal with the manner in which Parliament has or has not dealt with allegations pertaining to Mr. Bongani Bongo, a complaint that was lodged, and the lack of progress to this date that you are aware of in respect of Parliament's response. Could you just briefly summarize the story there, please?
Yes. My understanding of the complaint itself and the substance of that complaint is that Advocate Vanara, who used to be the registrar of the Joint Committee on Ethics and Members' Interests, as well as the evidence leader of the Portfolio Committee on Public Enterprises inquiry into ESCOM, that he was bribed in Parliament by Mr. Bongo to tone down the heat, if I can put it that way. And what transpired subsequently is, to me, an illustration of a problem of Parliament's culture. And that problem is that Mr. Bongo then went to the High Court, if I remember correctly, and basically made the case that it is unfair that the process of the Ethics Committee's inquiry into said complaint is taking so long. And what the judge found, in essence, was that it is a result of his case in court that the process was further delayed. And the point I wanted to illustrate with that, and that issue still hasn't been resolved, according to my knowledge, but the issue that I'm trying to portray is that members themselves, members of Parliament, do not respect the processes and the internal accountability mechanisms that are there. For example, the Ethics Committee's proceedings. These are not respected, and I think there's an understanding, especially the ruling party, who effectively controls each and every disciplinary and ordinary committee in Parliament, that any complaint that's leveled against a member of the ruling party, if you're on the right side of things, will lead to nothing. And this is an illustration to me of that problem.
So if I can just refer you more specifically to paragraph 5.3.7, there, the Honourable Justice hearing that case records that Mr. Bongo's own complaint is inexcusably slow progress. That, of course, was quite some time ago from today, well over a year, I think. Am I correct?
Yes, I think so.
You say, if I understand you correctly, in paragraph 5.3.10, is that as yet no steps have been taken, no outcome has been communicated in respect of that extremely serious complaint, which, if the complaint is valid, would be the most egregious violation of the duties of an MP and of a minister.
Yes, precisely. And I don't want to preempt where we're going, but this is a smaller example and one that we are less directly involved with as an organization. As an organization, we've submitted two very substantive complaints. In fact, we received any substantive feedback. We have no indication of anything that has happened to those complaints to date.
I want to just interrupt you just to refer you to the parts of your affidavit that deal with that. Would you go to paragraph 5.7, I think, point 19?
Just 1 second, Mr. Freund. Just 1 second. Can I find out from the stenographers whether they hear what Mr. Freund and Mr. Johnston say quite clearly, because there are quite a few times when it looks like there are glitches. Mr. Johnston was making a comment a minute ago, and half of what he was saying, I think, couldn't come out clearly. They can hear. Okay, all right. Okay. Given these technical glitches, I think from your side, Mr. Freund, I can hear you quite clearly now. Mr. Johnston, being aware of these technical glitches, do your best to speak up and do so clearly. Thank you. You may proceed, Mr. Freund.
Thank you, Chair. Mr. Johnston, would you please turn in your affidavit at page 258 to paragraph 5.7.19.
I'm there.
And does that paragraph deal with the evidence you were just giving about 2 complaints that were furnished by OTA? And is it correct that there were complaints against the former Minister of Communications, Faith Mutambi, and the former Minister of Mineral Resources, Msebenzi Zwane? Is that all correct?
Yes, that's correct.
Now, can I ask you to move further into your affidavit to paragraph 5.8.104. Find that at page 298.
Yes, I'm there.
And you say there that those 2 complaints were lodged with Parliament's Joint Committee on Ethics and Members' Interests on the 16th and the 25th of October 2017, and you actually annexed them, is that correct?
Yes, that's correct.
And then you say, as at the date of deposing to this affidavit, which was in November of 2020, no tangible disciplinary action have been taken against either of the former ministers. They have since been appointed as the chairpersons of the Portfolio Committee on Cooperative Governance and Traditional Affairs and the Portfolio Committee on Transport in the National Assembly of Parliament, respectively. Is that correct?
Yes, that's correct.
And as of today, to the best of your knowledge, have you been advised of any outcome of either of the complaints that you lodged in October of 2017?
No, we have not.
I can take you back now to paragraph 5.5.16. You deal, and that's at page 237 of volume 1, you deal at some length over the next meeting had been pre-arranged in order to get to the bottom of the VR laser Denel controversy. It had been preceded by an earlier meeting, and fingers were pointing in different directions. And in Department of Public Enterprises, the Treasury, the ministers of those 2 departments, the old board, the new board. So this was a specially arranged meeting to bring all the parties together so that the committee would have an opportunity to probe and get to the bottom of the matter. Is that a fair summary?
Yes, that's correct.
Now, this you indicate in the 4th line, paragraph 5.5.35, was chaired by the then chair of the Public Enterprises Portfolio Committee, Ms. Letsatsi Duba, but she was also accompanied by the chairperson of the Select Committee on Public Enterprises and Communications, Ms. Prince. That select committee being a structure of the NCOP. Is that correct?
Yes.
So this is an important joint meeting. And what emerged at a very early stage of the meeting is that the chairperson informed the committee that the Minister of Public Enterprises, Ms. Lynn Brown, and the Minister of Finance, Mr. Pravin Gordhan, had forwarded their apologies for not attending the meeting. And I might indicate, Chair, that if one looks at page 378, which is in the annexure, one sees that the notification from the Finance Minister, according to the Chair, was on the 2nd of September, in other words, some days before this meeting. And you also reflect that the committee had been unable to get the previous board members of Denel to attend this very meeting. Is that correct?
Yes, that's correct.
And so the fact that the two ministers were not there and the former board was not there, notwithstanding that this was an arrangement that had been made by agreement from months earlier to finally try to get to grips with the Denel, via at least some of the members present were extremely disappointed. Ms. Matsoni, for one, is that correct?
Yes.
And so you describe in your affidavit how Ms. Matsoni and other members of the opposition objected in strong terms to the non-attendance of required participants and the fact that no alternative arrangements have been made, notwithstanding prior notifications to the chair that certain persons wouldn't be able to come. And an argument developed, and eventually the opposition MPs all walked out of the meeting. Is that correct?
Yes, that's correct.
Now, subsequent to them walking out of the meeting, the Denel leadership were then invited to make a submission which, as it were, reflected their side of the story. Is that correct?
Yes.
And I want to take you to paragraph 5.5.42. Because this reflects, according to your evidence, the conclusion that was expressed. Now, Chair, at this stage, could I ask you please to go to the actual source document, the annexure, which is in bundle 1 at page 381. Perhaps in fairness, just for us to get our bearings, perhaps we should start at page 376, which is the beginning of the document.
Yes, Mr. Freund. Oh, okay. How much time will be needed? 10 minutes. Okay, all right.
Major deal.
Well, I think
Is that essentially
Mr.
the
Freund was
conclusion
not
reached
aware.
at this meeting?
Yes, exactly.
Mr. Freund? Mr. Freund? I think he can't hear me. Mr. Mr. Johnston, can you hear me? I think Mr. Johnston can't hear me either. You can't hear me?
Okay.
You can hear me? You can hear me, Mr. Johnston?
Yes.
Okay, I think Mr.
Yes, I can, Chair.
I think Mr. Freund can't hear me.
I can hear you now, Chair. There was a brief moment when I couldn't, but I now hear you clearly.
Yes, well, you both disappeared from the screen for maybe a minute or two or a minute or so. And I think from your side, you may have been continuing with your questions and Mr. Johnston giving you answers, but I could not hear you. So I think we'll need to take the tea adjournment now because it's the right time, but give the chance to the technicians to attend to the technical problems. Maybe I should not have said in the morning that we have been doing quite well in terms of technical problems. Maybe I've invited the technical problems. Okay, let's take the tea adjournment and we'll resume at 11:30. We adjourn.
So, John, are you there?
Yeah, I am, but I'm not at the hearing venue. I think what happened was the connectivity dropped that side and the connection had to be reattached.
So, when you say that side, do you mean at the commission side or at my home or where?
It's the hearing venue.
SC, can you hear me now?
Yes, I can hear you.
Thank you, SC. I can also hear you loud and clear. Mr. Johnston, can you hear me?
Yes, I can.
Thank you, sir. We are about to begin shortly. Thank you.
Can I ask you whether you have any idea at what stage you lost me? Where I had got to when you lost sound?
Okay, let me quickly check. I'll come
Answer
back
that
to you.
one. It was your last question just before the judge came back.
All right. So thanks very much.
You only missed that question.
Okay, thanks.
Okay.
Okay, let's continue. Yeah? So you'll need some time? 10 minutes. Okay, all right. We'll adjourn again.
Hello, SC? Yes, SC. Can you hear me very well? I can't hear you from my side. Okay, I think there's still a problem because we cannot hear you. I can see you talking, but I can't hear you. Let's quickly check with our technical team.
Unmute.
Oh,
Right.
yes.
I
Yes.
was sorry, that was my fault. I was on mute. Can you hear
okay.
me now?
Okay, yes, I can hear you very, very loud and clear now. Thank you, sir. We are about to begin again. We are about to try
Thank
again.
you.
Thank you. So, sorry, SC, is Mr. Johnston available as well? Mr. Johnston?
Yes, I am.
Okay, thank you. Thank you, sir.
I have Mr. Freund on the other screen and not on this one. Is that going to change, or what has happened? It's blank on this one. I prefer to see them on the one that is near, not the ones on the wall. I can say, Mr. Johnston. Can you hear me, Mr. Johnston?
Yes, Chair.
Thank you. Mr. Freund, can you hear me?
Loud and clear, Judge.
Yes, okay, all right. Let's proceed.
Thank you, Chair. Chair, when we broke, you indicated to me that you believed, I'm sure correctly, that I had asked some questions of Mr. Johnston that may not have been transmitted. Can I inquire from you, Chair, whether you heard me refer the witness to the document in the bundle that starts at bundle 1, page 376, the minutes of the Denel Asia meeting with the PCPE?
Yes, I did hear. That's where I am.
All right, then I'll pick it up from that point, if I may.
Okay, all right.
Thank you. Mr. Johnston, the document that starts at page 376 is the PMG minute of the presentation on the Denel Asia issue, which was intended to be attended by the Denel Board, by the National Treasury and the Department of Public Enterprises. Is that correct?
Yes.
And this meeting of the 7th of September 2016 had two chairs. Ms. Letsatsi Duba, who was the chair of the Portfolio Committee on Public Enterprises, and also Ms. E. Prince, who chaired the corresponding select committee of the NCOP. Is that correct?
Yes.
And I think that before the interruption, you had confirmed that essentially what happened was that certain expected role players were not there, that this led ultimately to a walkout by the opposition members, and that the ANC members stayed on in the meeting and that there was then a presentation by the representatives of Denel. Is that correct?
Yes, that's correct.
I think we were really at that point when communication lines were apparently dropped. I'd like to take you to the end of that document, to page 381. And I just want to read into the record and invite your comment. The record says, Ms. Prince, the co-chair of the meeting, said it was quite clear that there was nothing close to a scandal in the Denel Asia deal. Is that the basis on which the meeting concluded?
Yes, it is. And I would just like to comment a little bit further on that. The persons who represented Denel were Mr. Richard Seleke and Mr. Daniel Mansha. Now, we've laid criminal charges against Mr. Seleke as well. And I'd just like to extract the core narrative of that meeting. And that was one where this deal between Denel and Denel Asia was being pushed very strongly by Mr. Seleke in particular. And he went so far as to acknowledge, well, firstly, he negated comments or allegations that the Gupta family were major shareholders in that Asian company. But he did not deny that Mr. Salim Essa was the majority shareholder of that company. Mr. Salim Essa, we've also laid criminal charges against, and he is a very close associate of the Gupta family. And clearly, in my view, Ms. Prince in particular was on Mr. Seleke's side and very much agreed with his sentiment, despite the fact that it was on record there that the National Treasury did not approve of this deal, and they said that it was in transgression or not in alignment with the Public Finance Management Act.
In fact, it went further, did it not? It was acknowledged at that meeting on behalf of Denel that by statutory law, it was imperative, if that was to proceed, for the approval to be obtained of the National Treasury, and it was acknowledged that it had not been, that approval had not been received. Am I correct?
Yes, that's correct. And further, Mr. Seleke bemoaned the fact that they are already operating in a very restrictive legislative environment. And what he's saying, in essence, is that he's irritated by the rule of law and that he would prefer that these restrictions would not be there. And clearly he had a very strong intention to have this partnership happen, despite the fact that it was in contravention of the laws that really govern how public officials spend taxpayers' money.
And all of this was apparent when reads the transcript, the PMG transcript, and it precedes the conclusion by the co-chair, Ms. Prince, that it was quite clear that there was nothing close to a scandal in the Denel Asia deal. Is that correct?
Yes, and I think it makes it quite clear that there was a preconceived or premeditated conclusion to this meeting. And whether or not the opposition members were there and whether or not they objected and whether or not they decided to leave, that would have been the conclusion. And this is one of the problems that I've observed in Parliament very frequently, is that actual decisions are not taken on the record when these deliberations are happening. These decisions are taken beforehand, and then they are acted out when the meeting actually occurs.
Thank you. I want to move on to a different issue. If you would turn, please, to page 259.
I'm there.
And you will see in paragraph 5.7.20 and following that you start to deal there with what I will refer to as the Frolic letters, a set of letters from Mr. Cedric Frolic, who then House Chairperson for committees, to the chairs of various portfolio committees,
Sorry, Mr. Freund. I thought you said, or did you say 259?
Page 259 in bundle 1.
Okay, no, I
Paragraph-
think I did hear you correctly, but I went to 359 instead of 259. That was not your fault. Okay, what paragraph did you say? Did you refer us to?
5.7.20.
Okay, thank you. I've got it.
And in that paragraph, Mr. Johnston, you deal with a topic that has already been canvassed with certain earlier witnesses, which is to say a set of letters issued in mid-June or thereabouts to the chairpersons of 4 portfolio committees, in which they were requested in their committees to investigate what we can broadly refer to as allegations of state capture or the like, insofar as it related to the areas of jurisdiction of those 4 committees. Is that correct?
Yes.
Now, you do annex those letters. I'm not going to necessarily need to take you to that. But what I would like to take you to is to paragraph 5.7.23, because this particular piece of information is not canvassed in the evidence of any of the other witnesses. And this relates to a press statement which you actually annex to your affidavit. You annex it as Annexure 4.2a. I'm not going to take you there because you quote the relevant part in your affidavit. And what this says, perhaps I should read it into the record. In the light of the recent accusations of state capture linked to alleged emails involving a number of ministers, parliamentary committees have been directed to urgently probe the allegations and report back to the National Assembly. And it then goes on to explain how this is in accordance with the rules. And it says in the penultimate paragraph, while no specific deadline has been set for the submission of the outcome of these investigations, the committees have been urged to begin with the work and report their recommendations to the House urgently. And then it continues, Parliament, as a representative body of the people of South Africa, shoulders the constitutional responsibility of ensuring that matters of public interest are dealt with as expected by the people. So you can confirm, can you not, that that is the media statement that was issued and which is annexed to your affidavit?
Yes, I can confirm.
Now, a great deal of your affidavit from that point onwards consists of monitoring the progress in those 4 committees and certain other portfolio committees. Am I correct?
Yes.
For reasons of time, I'm not going to take you through all of that. I'm going to be selective, but I do wish to refer you to your reference to the secret ballot judgment, which we see in paragraph 5.8.4 of your affidavit. That's at page 263. And you quote a little more extensively than a previous witness, a pertinent extract from the Constitutional Court's judgment. And you then go on thereafter to make some judgment. This is in paragraph 5.8.5. Perhaps you might read into the record the first 2 or 3 sentences of that paragraph and then speak to that point.
So I said that OUTA contends that this conflict between upholding constitutional values and party loyalty occurs in parliamentary committees daily. We argue that this imperative that says party political representatives must, as their absolute and unfaltering priority, enable the people to govern through them is not being realized. Would you like me to go further?
Yes, please.
Our members of the Parliamentary Office have witnessed countless instances of party political decision-making, both within and outside of formal parliamentary fora, that are in no shape or form taking the public interest into account. On the contrary, we have witnessed decision-making that knowingly contradicts the explicit best interests of the public at large, but serves party political purposes over the short, medium, and especially the long term.
In fact, if you'd also deal with the next sentence.
This cannot be considered separately from the cadre deployment and electoral system at play. And then I refer to the recent case of independent candidates having to be allowed to be elected to the National Assembly. Right. Would you like me to?
No, that would be fine. Now, when you make that, with respect, damning criticism, do you feel it's a fair criticism, and do you feel that you can substantiate that from your personal experience and the observations made by your organization, not only relying on what you've seen written in PMG reports, but in sessions that you have personally attended?
Yes, I can. And I can give a very concrete and immediate example of that. And that isn't covered in much depth in this affidavit, but I think I do cover it somewhere. And for instance, there was a planned inquiry into the Department of Water and Sanitation, the former department.
Well, let me just stop.
This was something.
Let me just stop you there. I'll refer you to paragraph 5.9.4 of your affidavit. And really, from 5.9.4 all the way through to 5.9.13, I think this is the portion of the affidavit in which you address this issue. So let's deal with this issue now.
Okay. I can summarize it. There was a very explicit intention to hold this inquiry, and we were very welcoming of it, as were many other stakeholders. And there was an entire procedure. There were several meetings that I personally attended in planning this inquiry. And
what was the intended scope of the inquiry?
It was the financial governance of the Department of Water and Sanitation, I think, particularly under the custodianship of the former Minister Mokonyane. And this was something that was going to be conducted by both SCOPA and the then Portfolio Committee on Water and Sanitation. That was Mr. Temba Gori and Mr. Lulu Johnston. Now, Mr. Lulu Johnston was the main man, if I can put it that way, in this planning process. And Mr. Gori and his committee, SCOPA, would be supportive. And we, in preparation for this, compiled very substantial submissions for these committees to consider. And there was a draft schedule. And everything was really in place. And I think there was some representations from the SIU as well. That was in camera, so I'm not sure what transpired there. But that happened. And ultimately, it was cancelled. And there was no notification as to why this is happening. So in a meeting that I attended, I urged a journalist sitting next to me to approach the chairperson and ask him why this is no longer happening. I figured that he might not want to tell me. And he told her that it was because the elections were coming up. I think this was in March, and I think the elections were in May. It was sometime soon. And Mr. Johnston acknowledged to her, off the record, that is why the committee will no longer proceed with the investigation or with the inquiry. And we tried subsequently to re-establish this, and we're still in the process of trying to revive this, but it has not yet come to pass.
Now, I want to take you back to where we were in your affidavit, back to page 264. And in paragraph 5.8.6, you deal with the question of the current electoral system and the impact on accountability to Parliament. You may have heard this morning that that issue was debated with the previous witness. I don't want to deal with that at length, but in crisp summary, what is your stance on this issue?
So I think I should get to this toward the end, but in short, for now, I can say I don't think that electoral reform, whilst I think it is an essential thing that needs to happen, I don't think it's a panacea for this issue. But what I put here is that the obsessive prioritization of equality in political voice that has precipitated in a system of proportional representation through political parties has nullified any possibility of real accountability in Parliament. And that is my view. It is in almost every instance. I'm also going to refer to this later on, but when we come to the Code of Conduct and the rules of the National Assembly and the NCOP, you can see quite clearly that in every process, including disciplinary processes, there is a rule of majority that can override any finding. This is the case when it comes to findings of the Ethics Committee, and it's the case in virtually every inquiry that's been held. And my view is that because there is a majority that consists of a single political unit, being the ruling party, in this case having a very large majority, it means that they have absolute power. It means that regardless of any information put before them, any allegation, they can simply decide not to do anything about it. And that's what we've seen in practice. And I've observed this myself personally. This is not based on what I've read in PMG at all. I've seen this. There have been bills that come to Parliament from the various departments, and there is a unilateral decision of what that bill is going to do, where it's going to go. And in many instances, there seems to be a meaningful debate on a certain issue, whether it be an issue of oversight or an issue of policy making. And there would be a pause when there's some confusion. Members of the ruling party would step outside and make a decision amongst themselves by consulting probably their political directors, come back into the room and announce a different decision or a particular decision. And that is, in my view, what really limits accountability. Because in the executive, where I say that state capture has transpired, where money really flows, that is the same case. So I think it is a system that is being exploited, where comrades are expected to hold one another accountable, and that simply doesn't work.
All right, thank you. I want to move on to paragraph 5.8.7 of your affidavit. That's at page 265. And you refer there to a 175-page report that OTA published and submitted to the Speaker of the National Assembly on the 28th of June 2017, which was entitled "No Room to Hide," and sought to substantiate allegations of state capture. You made such a submission, I take it.
Yes, we did.
Now, you deal then in paragraphs 5.8.9 and following with a meeting of the Portfolio Committee on Public Enterprises. This, of course, was fairly shortly after the date on which that committee, according to the evidence we've heard of Ms. Mazzoni and of Ms. Ranko, had decided to start a process of inquiry into allegations of state capture. And did you attend this meeting on the 25th of July?
Yes, I think I did.
And you say in paragraph 5.8.10 that OTA then provided its No Room to Hide report to the committee, presented a summary of its contents for consideration. And you then go on to explain, as it were, the nub of the various allegations in your lengthy report. And that was considered, as I understand it, and taken into account by the Portfolio Committee on Public Enterprises on that occasion, and presumably it informed some of their subsequent work.
Yes, I believe so.
Now let's turn to the Portfolio Committee on Mineral Resources, and I want to take you to page 267 and starting at paragraph 5.8.18. And I think it's necessary for me to make clear both to you and to the chair that on this issue, it's not currently anticipated that politicians who were directly involved will be called to testify about the events in this particular committee. And so for present purposes, we rely quite heavily in relation to this committee on the content of your affidavit. And that's why I'm going to focus on that in some detail in your evidence that now follows. Now, if we can look at paragraph 5.8.18, you refer in the fourth line to annexure 4.7a, and that is the letter from Mr. Froelich. I think we'll find that at page 531. Let me just check that, please.
And that's 500 and?
531, but perhaps I should take you to 530 just to set the context. Now, this is the PMG minute or summary of the meeting of the Portfolio Committee on Mineral Resources and Energy on the 16th of August 2017, chaired by Mr. S. Luzipo. Is that correct?
Yes.
And if we then go to page 531 through to 532, we find that there was some discussion on that occasion about a letter. If you go to the middle of page 531 under the heading Letter from House Chairperson, State Capture Allegations. Do you see that?
Yes, I do.
And it says the following. The chairperson read a letter from Mr. Cedric Froelich, the House Chairperson, which had been sent to the committee on 20 June 2017. The letter was not circulated to the general public attending the meeting. In essence, the letter was a request for the committee to investigate the various allegations in the media on the state capture of organs of the state, some implicating the Minister of Mineral Resources. He wanted the committee to report back to the National Assembly at the soonest opportunity once the investigation was done. Now, let me just pause there and say this. There does not seem to be any controversy from anybody that such a letter was sent to the chair of this particular committee, as we see reflected here. But for reasons unclear to me, we have been unable to come up with the copy of that very letter. But it seems clear, does it not, that the letter was sent and drawn to the attention of this particular portfolio committee.
Yes.
And what you then deal with in your affidavit from paragraph 5.8.19 is that Mr. Luzipo reports to the committee, and you are really here summarizing what we find in more detail in the PMG report. Mr. Luzipo reported that he had responded to the House chairperson by asking for terms of reference to guide the committee in its investigations. That's what you discern from the PMG report. Is that correct?
Yes.
And I take it, Mr. Johnston, that although you attended many meetings, you're not certain that you attended this meeting.
I'm not quite sure because I was trying to spread myself between all these inquiry meetings.
So your evidence rests here largely on the PMG report.
Yes, I'd say so.
And then you say in paragraph 5.8.20 that the PMG minutes shows that several ANC MPs present advanced arguments against conducting the requested investigation. You say Mr. Mandela, a member of that committee, said that the committee should wait until terms of reference were in place, and also said that he was not sure what emails were being referred to and what media was being referred to. And one sees, if one goes to page 531.
Sorry, Mr. Freund. Mr. Freund?
Chair.
I think when you were reading, I don't know whether it was deliberate, but it doesn't seem deliberate. You skipped a line where you said he was not quite sure what. I think the next line is what the House chairperson wanted the committee to do. You went to the next line, what media was being referred to, I thought.
Yes. I stopped.
Was it deliberate?
Particular. You're correct. It does continue.
I thought it was not deliberate. If it was deliberate, that's fine.
No, it was deliberate, because at that point, Chair, I wanted to take you to the source document for that particular point.
Okay.
The source document,
Okay.
page 531.
541.
531 in bundle 1.
Oh, that's where I am.
And in the fourth last paragraph on that page, you will see that that is the source of what Mr. Johnston is setting out in his affidavit, and that Mr. Mandela says that he referred to the rural village of Mveso in his constituency, where newspapers and other forms of media were not readily available. He was adamant that the committee should not be seen to be chasing rumors and had to rely on facts, which, as I understand it, was put up as a reason not to accede to Mr. Frohlich's request that this committee at this time should pursue this inquiry. Is that how you understand it, Mr. Johnston?
Yes, it is. And I think I'll get into more detail, but this is the beginning of an extremely extensive series of excuses that were put forward not to hold an inquiry or not to implement substantive oversight. But what one could interpret from what Mr. Mandela is saying here, that he does not know what it means to carry out oversight of this issue. And I'll get to that point later on, but perhaps that is a valid point.
All right, let's lay a foundation for that. Let's go to the next paragraph in your affidavit at page 268, and that's the paragraph 5.8.21.
I'm there.
And there you refer to the fact that this PMG report that we have shows that Mr. Lorimer of the DA then handed out sealed envelopes marked Gupta emails to committee members, and that this provoked an angry reaction from, amongst others, the chairperson of the committee and Mr. Mandela as being, so they said, in breach of parliamentary and committee protocols. Is that correct?
Yes, that's the argument that was put forward.
And then the chairperson says something interesting that you deal with in paragraph 5.8.22, because he is quoted in this report as saying that asking for terms of reference and further clarity should not be seen as stalling or evasive. And he said that, and I quote from the minute, there was already broad agreement within the government that there had to be an investigation. All that was needed from the committee's perspective would be how to go about investigating the issue. And he closed the discussion by proposing that a letter be drafted to the House chairperson for guidance. In other words, the chairperson was not disputing, in fact, was proclaiming that what he called the government was in broad agreement that there had to be an investigation. You agree?
Yes.
Now, in paragraph 5.8.23, You refer to a subsequent letter from Mr. Froelich to Mr. Lozipo, dated the 23rd of August 2017. You refer to that as Annexure 4.7b, and could I refer you to page 535, please, in the bundle? I'm going to read this letter into the record. Dear Honorary Chairperson, your letter dated 18 August 2017 is at hand and refers. I confirm that we've met and discussed the contents thereof in a meeting earlier this afternoon. We also agreed to an approach in dealing with the matter at hand. Over the last 2 months, serious allegations has been made in the public domain about state capture and the alleged role of certain members of the executive. The sources of authority of the National Assembly is contained in Rule 2 and is primarily derived from the Constitution of the Republic. Parliament is, amongst other, legally bound and empowered to exercise oversight over the executive and to keep it accountable for executive action. Allegations against any member of the executive warrants the attention of the relevant committee to clarify issues under contestation. The relevant member of the executive must be provided with a fair opportunity and platform to respond and, where possible, clarify allegations in the public domain. This should be the point of departure before the committee determines its next course of action. Furthermore, the committee must perform its functions in terms of Rule 167 of the Rules of the National Assembly. Finally, the committee must determine the resources required and communicate the needs to my office. Now, the existence of that letter and what was conveyed in that letter was then drawn to the attention of the committee itself as you deal with, let me put it this way, there doesn't seem to be any controversy that that letter was drawn to the attention of the committee in due course. Now, what I want to move on to is the next meeting, which you deal with at page 269, paragraph 5.8.24 and following. And there we see that that letter that you've just been referred to was discussed, and that it was clear on the need that the letter, Mr. Froelich's second letter, was clear on the need to first call the minister to account and that the committee should then seek legal advice on the way forward. There's then some discussion, and you indicate towards the foot of the page that the ruling party majority voted to allow the minister to come to the meeting and account. And what they really wanted was the minister, which is Minister Zwane, to come there and then to that very meeting and be called to that meeting. Is that correct?
Yes, I can comment further if you'd like.
Yes, that's exactly what I'd like you to do, please.
Okay, so my view is that there had been a strategic decision to get the minister to come as soon as possible. And this obviously wasn't standard procedure. As you can see in virtually every other committee that either intended to or actually held an inquiry, there would first be a plan of how that inquiry would go and what exactly they would talk about and what the intended outcomes would be, obviously. In this instance, from this moment onward, and this is very early in the process, there was a decision taken that the minister must come immediately or as soon as possible. Now, my view as to why they did that and why it would work in the favor of the minister and the organization he represents is Section 58(1) of the Constitution, which really makes members of Parliament and cabinet members immune to any civil or criminal proceedings resulting from anything they say in Parliament. So when we get there, I'll refer to this again, but some of the utterances made by the minister when he ultimately came, he came one time and he spoke.
let's wait until we get there. Let's just deal with where we are for the moment. If I can take you back to paragraph 5.8.25, you say, we see this from the fourth line of that paragraph, that Mr. J. Lorimer and Advocate H. Schmidt of the opposition argued that the minister should not be summoned until the proper processes have been put in place and the committee had received advice from the parliamentary legal advisor. So there was some debate and argument about whether it's appropriate just to call the minister immediately or whether there should be certain processes put in place. But the decision by the majority is we call the minister immediately to this meeting now. Is that correct?
Yes.
As it happens, the minister was unable to come immediately to that meeting. And so he didn't come to that meeting as the majority had been hoping. Is that correct?
Yes.
Now, you resume dealing with this issue at page 271 of the bundle, paragraph 5.8.33, where you deal with the meeting of the Portfolio Committee on Mineral Resources on the 18th of October 2017. And you refer to the annexure, Chair, just for your convenience, if it isn't already in your papers. The annexure 5.1 is in this bundle at page 545. I'm not going to go there at the moment. But what is reflected in that minute and recorded by you is that at the outset of this meeting, I'm reading from the fourth line of this paragraph, at the outset of this meeting, the committee chairperson stated that there had been a command, that's what he says, from the House chairperson to have a meeting with the minister convened and for him to respond to the allegations of state capture. And in the light of this directive, says the chairperson, the primary task was to ask questions related to accountability of the executive. That's a fair summary I give, is it?
Yes.
And what then happens is that the minister does present himself and is questioned on a diversity of issues where there were allegations in the public domain that had some bearing on his portfolio or his personal experience. And you deal with that at quite some length in this affidavit, is that correct?
Yes, I do.
Now, one of the points that the minister made, and you deal with this in paragraph 5.8.36, and when I refer to the minister here, we're referring to Minister Zwane, that the minister made was that he asked whether he was being put on trial publicly without allowing the legitimate structures like the courts to do their work. And he, on that occasion and other similar comments were made, he was really suggesting, as I read the report, that whilst he was not disputing that this committee could call him and ask him questions, he was really asserting that it was not their proper role, that the proper structures to deal with these issues were the courts, the Hawks, and other entities rather than portfolio committees. Is that a fair summary?
Absolutely, and similar to what was said in 2013 by Minister Jeff Radebe, he also gave the impression that this is not an issue that is relevant and that this is not something that really affects South Africans, and therefore parliamentarians need not concern themselves with this issue.
I want to jump forward through to paragraph 5.8.41. The minister had been asked a number of questions which you deal with in your affidavit, and he responded, so you say, that he had answered these questions more than 10 times on different platforms, and he said he wished members would take notes so they do not bring them up again. And he then went on to deal with those questions that had been put to him. And one of those questions related to the Glencore Tegeta transaction. Am I right?
Yes.
And in the middle of page 275, his assertion was that the owners of the company had been Glencore, that he, Mr. Zwane, was looking for an interested buyer, and he was told that only one company called Tegeta showed interest, so he took it upon himself to bring the two companies together to try to resolve the matter, and this is when the trip to Switzerland occurred, because he was told that the owners of Oak Bay resided there, correct?
Yes, he said so.
And then he was asked about the feeder dairy issue, and he was asked, we see in paragraph 5.8.44, which is on page 277, he was asked about the Waterkloof Air Force Base issue. We see in paragraph 5.8.45 that he really thought that this was not an issue that should be canvassed with him on this occasion. And I want to take you now to paragraph 5.8.46, because there has been, as the minute shows and as your affidavit reflects, there has been an extensive period of questioning of Minister Zwane at this meeting. But in paragraph 5.8.46, towards the middle of the paragraph, the committee is now beginning to reflect on, well, where do we stand and where will we go? And you say that the chairperson reiterated questions that the minister did not answer. He noted that after the process had been completed, the committee will have to assess the answers provided by the minister. And then in the beginning of paragraph 5.8.47, you report that members of the opposition parties were dissatisfied by the minister's answers, in particular about the role he and or his advisors played to assist the Gupta family in the acquisition of Optimum coal holdings and the facilitation of a prepayment from Eskom for coal supply from OCH. So that is what the minutes show was then discussed once the questioning of the minister was completed. Is that correct?
Yes.
And if we move on to paragraph 5.8.49, it seems that that conversation that we've just referred to took place while the minister was still present. In fact, if we go to 5.8.48, we see, as we often do, the minister or the person concerned invoking the sub judice rule. Is that correct?
Yes.
Certain questions he didn't want to have to answer because of the sub judice rule. And then it seems that what came to the fore, what's referred to as a certain set of emails, it seems, if one reads this with some other knowledge, this must be a reference to what had come to be known as the Gupta leaks, that as for the emails that were referenced, the minister said that he'd not had an opportunity to respond to them, and he questioned by whom these emails were validated. Perhaps, he added, these emails should be tested before he can be probed about the content contained in them. He asked if they had been tested sufficiently to declare that they are admissible in court. And he was reluctant to be drawn into an engagement as to what the emails purported to show. Is that correct?
Yes, and I would just like to highlight that he was dictating this conversation, and there was no objection that he should very much be able to comment on the veracity of those emails if he were presented with any of those contents. He simply said that that is not something that he is willing to discuss because it is not necessarily a legitimate sort of evidence.
And then if I take you to paragraph 5.8.51, the person, you say, said that the committee would write to the minister officially to engage further, but noted Well, I'll leave it at that. So there was to be a further communication to the minister. And I want now to move on to the events of the 25th of October 2017, which you then deal with at page 280. And what you report there is that the chairperson of the committee informed the members of the committee that a further engagement date had been requested with Minister Zwane to discuss allegations of state capture, and the chairperson's hope was that this would be on the 1st of November 2017. Is that correct?
Yes.
I can then take you to the next page, the meeting of the 1st of November 2017. And what you then deal with in some detail is that it had been expected that on this occasion, Minister Zwane would face further questions, as had been agreed at a previous meeting, but that he had written on the previous day, the 31st of October, to say he was unable to attend the meeting, citing a cabinet meeting and other business issues, and that arising from that, the committee agreed that a new date had to be agreed with the minister urgently, and an agreement was reached within the committee that it had first to conclude its questions to the minister before it could decide on an appropriate course of action based on its findings. Is that correct?
Yes.
And in paragraph 5.8.58, you make the point that the chairperson recorded that the members had not finished questioning the minister, so this had to continue to enable the committee to conclude phase 1 of its investigations and move on to phase 2. So the intention was get the minister's position on record, understand the minister's position, and thereafter embark on what might be called a more intensive inquiry into the issues. Is that correct?
Yes, that's the way it came across.
Now, there was then a further meeting on the 8th of November, which you deal with later at page 282. And it's recorded in paragraph 5.8.60 that the Director General had written to the committee confirming that the minister was available on the 28th and 29th of November for this resumed questioning of the minister. And there was consensus that it was regrettable that the 30th, that this was so far away into the future, because the 30th of November was the last day before leave. But nonetheless, the committee members present all agreed that since the minister had proposed the 28th and the 29th, those were the dates on which the minister would be expected to come and to continue to face further questioning. Is that correct?
Yes, they were really trying to bend over backward in order to get him to come and account.
So he was supposed to be there on the 28th. Now, you make no entry in your narration about the 28th, but you deal with the 29th. And you say in paragraph 5.8.63 that on the 29th of November, the committee held a further meeting. During its meeting, the chairperson said that the committee had been supposed to deal on the previous day, i.e. the 28th, to which we've just referred, with questions to the minister so that it could finalize matters and deal with the way forward. But the minister had declared his unavailability with reasons, and the meeting had therefore been shifted to the 29th. And then in paragraph 5.64, the chairperson asked the secretary to read out the reason for the unavailability of the minister at that day's meeting, which is to say the 29th, the second of the 2 days scheduled. And the secretary said that the correspondence from the minister's office stated that the minister was still recovering from illness. That is what the records reflect. Am I correct?
Yes.
So if I take you to paragraph 5.8.69, after much discussion, the chairperson suggested that the minister be given the date of the 24th of January. If he did not appear, the minister would be asked to suggest an alternative date. And if he did not appear on the alternative date, then the committee would decide what action to take, and the minister agreed to that proposal. That's how this meeting ended off. Is that correct?
Yes, and I should note, already at this point, there was disagreement from opposition parties that this should be accepted and that these apologies are legitimate, but members of the ruling party insisted that it should be accepted. And the resolution that was there in every instance of this attempt to get the minister to come on account was that we'll deal with it later.
All right. Now, I'm going to be taking you in a moment to paragraph 5.8.70, but before I do that, can I take you, please, to bundle 1, page 574?
There?
That is the media report to which you are referring, is it not, at paragraph 5.8.70?
Yes, it is.
And that is the media report on the very date, the 28th, that the minister was supposed to have been the first day of his attendance, where the reporter, two reporters, say this: a jovial and joking Mosebenzi Zwane on Tuesday evening, that is that evening, became an ill minister of mineral resources on Wednesday morning. Mr. Zwane was at a surprise ANC Free State Provincial General Council on Tuesday evening, where News 24 saw him joking with ANC comrades. And you draw attention to this as a factor suggesting that there may be suspicion as to the genuineness of the excuse given by the minister for not attending the meeting on the Tuesday the 28th and Wednesday the 29th. Is that correct?
Yes, that's precisely correct. And members of the committee would also have access to this media article, but they didn't seem to care about it.
Now, you then jump forward to the 21st of February. Bear in mind that what we had expected was that this was going to happen in January, but we now find ourselves at the 21st of February 2018. And by the way, in the interim, of course, the present Commission of Inquiry had been formally established. On the 21st of January, according to the PMG minute, which you summarized, the chairperson, and I'm now referring to paragraph 5.8.72, the chairperson of the committee said he had received 2 letters as to why the minister would be unavailable to appear before the committee. In the first, it was claimed that the minister was scheduled to answer questions in the NCOP. The chairperson had pointed out in reply that there was no NCOP meeting that week and that the 21st of February was a date requested by the minister. The chairperson recapped to the committee that it had not been able to proceed on the 14th of January as initially intended because of member training, so we can't blame the minister for that. The date had therefore been moved to the 14th of February. But the minister had said he would be writing exams on the 14th of February, and that was when the meeting had been shifted to the 21st of February at the suggestion of the minister. So the reason why we've had this long gap from November to the 21st of February is because the minister has specifically requested this date. That's what the records show, am I correct?
Yes.
Carrying on from your report to the affidavit. In the second letter, a different reason was given for the minister's unavailability on the 22nd of February, namely that he had to attend a select committee meeting and then a cabinet committee meeting. And you then, in the page or two that follows in your affidavit, you summarize the frustration by the members of the committee at the actions of the minister, and especially you say the flimsy and possibly untrue reasons for being unable to attend meetings, even when the minister himself had set the date for the meeting. And so the chairperson says, well, we're going to have to decide what to do, and there are various discussions. And if I can pick up the narrative at the foot of page 286, members began discussing the possibility of moving towards an inquiry without delay. The chairperson pointed out that the minister had already made an appearance before the committee. It was, says the chairperson, the dissatisfaction with his answers to members' questions, his evasive manner of responding, and the fact that members had more questions that had led to the attempt to get the minister to appear a second time. And then you make the point in paragraph 5.8.79, the committee finally decided that the way forward lay in setting aside efforts to question the minister again and to commence with preparations for a formal inquiry. The committee resolved to meet the following week to determine the scope, content, and technical details of the inquiry. So it seems from your affidavit that their patience has now been exhausted and there's going to be the required inquiry. Is that a fair summary?
Yes, that's how it seems. But it seems to me that it's a premeditated intolerance at this point, because now more than 6 months have passed. So suddenly there is dissatisfaction. So my interpretation is that there's a reason for that happening now. As you say, the commission had then started, but in the meantime, other things have happened as well.
Now, what you then deal with under the heading 25 April 2018 meeting is that terms of reference for that inquiry were in fact then determined. And if I can take you to page 584 in the record. Perhaps we should start at page 583.
I'm there.
At 583, we see that what we're reading is the PMG report on the meeting of the Portfolio Committee on Mineral Resources and Energy on the 25th of April 2018. And at 584, we see in the second paragraph, and this is under the heading Terms of Reference for Oversight Inquiry, the PMG report states the following. The committee agreed that state capture allegations were serious and resolved to institute an inquiry in line with the mandate of Parliament. Now, bear in mind, that is the mandate given in June of 2017, and we're now in April of 2018. The terms of reference were that there would be question and answer sessions during which the Honourable Zwane and any other relevant persons would testify before the committee. The inquiry would focus inter alia on the role of Honourable Zwane and the DMR in facilitating the sale of Glencore assets, non-compliance with the PFMA resulting in fruitless and wasteful expenditure, alleged breach by Honourable Zwane and of the Constitution, and the Executive Members Ethics Act as regarded conflict of interest, the handling of mining rehabilitation funds by the DMR, and the question of whether the dismissal of DMR officials were subject to external influence. And then it talks in more detail about the logistical intended arrangements. Is that correct?
Yes.
Now, you then say in your affidavit at paragraph 5.8.21 that OTA was contacted in May 2018. Perhaps if you just explain to the chair what this is all about.
Yes, Chair. There was an interaction between myself and the committee secretary, Ms. Nkandla Boss, and she was interested to interact with us, and I suspect, although we didn't reach the point of that specificity, but we were at the time involved in the Bank of Baroda case, and I think we had laid charges against the former minister as well. And basically what Ms. Boss was trying to arrange was for our legal team and the legal advisors of the committee to meet, to really help inform them about what terms of reference to adopt, and really just to give them some information. And the arrangement that they had been seeking was to come to Johannesburg to actually meet with us physically there, because it was their thinking that it would be much too costly to invite all the potential witnesses to come to Cape Town. because most of them were in Johannesburg, so they figured it would be cheaper to actually go to Johannesburg themselves and meet with us there. So we started those engagements, and we came very close to actually having that meeting, but that never occurred. And you'll see why in a moment.
I'm going to come back to that. You just referred in passing to the Bank of Baroda issue. That is not an issue that I have led you on, but it's dealt with in your affidavit at page 270 to page 271. And you refer there to urgent litigation before the Pretoria High Court brought by OTA, and it had a bearing on the issues that we're now discussing. Is that correct?
Yes.
So on the 25th of April 2018, the committee has agreed the terms of reference for its inquiry, and arrangements are now being put in place for your organization, one presumes amongst others, to furnish information of assistance to the Portfolio Committee in respect of the inquiry that it has now decided to carry on. Would you agree?
Yes, precisely.
But then what happens, we see at the meeting on the 30th of May, which you deal with from page 287 and follows. I'm going to just read into the record extracts from that. Paragraph 5.8.83.
Mr. Freund, we have gone past 1 o'clock.
Yes, indeed. Would this be the convenient time, Chair?
Yes. Let's take the lunch adjournment. We'll resume at 2:10. We adjourn.